This is Roger Clark, your host of the Fourscore and 7 Project, a production of the New Majority Foundation. Today, we return for part 2 of our interview with Professor Barry McDonald, Professor of Constitutional Law at Pepperdine University. Our subject today is money in politics. Is it a blessing or a curse? Has the Supreme Court blessed us or destroyed us? Professor McDonald, welcome back. Today we want to talk about money in speech in the United States. We all know how much money is spent on political campaigns, independent expenditures, and the number that is spent has gone through the roof in the last 10 or 12 years since a case called Citizens United was decided by the United States Supreme Court. People are troubled by how much money goes into speech, or at least into political campaign contributions, independent expenditures, and so forth and so on. So we have a very unique system in this country, the United States, which I think is a lot different from others. For example, maybe in Great Britain, they have a different approach to how they finance their campaigns. But the issue is money and speech. The Supreme Court, as I understand it, says that money is speech, but at least one prominent justice, I think it was John Paul Stevens, dissented and said money is not speech. What are your thoughts on this issue?
Well, money is clearly not speech. Money is a unit of economic exchange. Money is more like a bullhorn that can amplify speech and spread it further, right? So the more money you have, the more means of disseminating your speech you can, especially through channels of mass communication, and particularly ad buys is where most of that sort of money goes. So for the Supreme Court to recently sort of take the position that, you know, Congress or state legislatures, if they see sort of the problems that arise in terms of lawmaking by having to constantly be raising money for ad buys in order to win the next election or for whatever they're buying. So it consumes their time. The other problem with money is that some people have more money than others. Billionaires, corporations, unions. And so it sort of creates a situation where people can gain special access and influence over legislators the more they're willing to spend on behalf of those candidates. I just think that money should not be treated as a restriction on speech in the way that the Supreme Court has been doing that, but maybe sort of they should view it as what's called a time, place, and manner regulation of speech. If the manner that you want to speak is by buying ad buys and so forth, and we're going to allow the government more leeway to sort of prove that those sort of restrictions are needed. But the current conservative majority of the Supreme Court has taken, to me, to be a very disturbing path in this area of the law. They have come to say in a couple of major recent decisions that people with more money, and particularly if we're talking about corporations or unions or billionaires, to the extent that they're able to, with their money, to show support to a legislator, and to the extent that legislator reciprocates by showing gratitude in terms of giving them special access and listening to their petitions more closely, the current Supreme Court says, oh, well, that's just the way our democracy works, and that's built into our democracy. It's just sort of, as long as it doesn't amount to sort of a quid pro quo bribe, we'll spend this if you give us that, then that's as far as the government can go in sort of regulating that situation. Now, the more liberal justices, and I'm not liberal, I'm not conservative, let me just put this on the table right now. I'm an independent. The liberal justices have always said, oh, come on, that is not our vision of how a well-functioning democracy should operate. that those with money should have a greater say in affairs of governance than those without money. And we think that if by spending money they are gaining access and influence, that should be prohibitable and government shouldn't be barred from regulating that by notions of free speech. And I frankly think that they have the much sounder position on that.
Well, I mentioned the Citizens United case. I think it's about 11 or 12 years old now, and I just kind of threw it out there without defining it. Tell us a little bit about what Citizens United did in the realm of money in political campaigns and political contributions, independent expenditures, and so forth.
So what Citizens United did was, it was a 2010 decision, and so since the 1960s, 1970s, the Supreme Court has recognized that corporations enjoy some measure of free speech rights. That is even debatable because corporations are artificial constructs created by state law.
They don't have a vote.
They're investment vehicles for shareholders to be able to invest in a business without being exposed to undue liability. But they are money-making machines, hopefully, if they succeed. That's what they're designed to do.
CEO certainly hopes, and the shareholders certainly hope they're money-making machines.
So, and the people that are in corporations have plenty of free speech rights, including through political action committees and so forth. So to say that the corporation as a artificial construct has free speech rights, I think is extremely debatable. But
would that also be true with the union as well? I mean, that's an artificial construct too, because it is an organization.
Yes, sure. And there's a lot more corporations than there are unions. But it's the same principle. It's an artificial, fictitious legal entity created by law. And so I think the law should be able to put some reasonable restrictions on how they operate. But in the early 60s, the 1970s, the Supreme Court started saying that corporations do have some free speech rights, and in particular, there was a case that said corporations have the ability to spend money in connection with initiatives that affect their business. And the Supreme Court said, well, if it's an initiative that affects their business, the businesses ought to be able to spend on that and have the public hear their views on that. And I think that's fine. But then in 1989, corporations were starting to get involved in funding the campaigns of particular political candidates. And that's when government started to step up and say, okay, no, we don't think that's a good idea. You have disproportionate wealth. You have the ability to sort of dominate the marketplace of ideas on this. And so, if you want to speak to initiatives that affect your business, that's fine, but we're not going to allow you to sort of install the politicians with all your money that are going to sort of promote your pro-business agenda. And in 1989, in a 5-4 decision, the Supreme Court upheld that. They applied, you mentioned it before, strict scrutiny, the most demanding test, and they said there's such a threat here that corporations will sort of dominate the marketplace of ideas and certain other rationales, that they said that we think that these laws restricting corporations from funding political campaigns are justified. Well, Citizens United came along with a more conservative support 30 years later. The Supreme Court actually reached out, not acting minimally like they say they only decide what's necessary. They didn't need to decide this. They actually reached out and posed the question, should we overrule that 1989 decision? Well, once that was out there, you knew the writing was on the wall. And sure enough, in a 5-4 decision, in Citizens United, the court overruled that earlier 5-4 decision, went 5-4 the other way, the conservatives in the majority, and basically said, no, we think that both corporations and unions have free speech rights to be able to spend general treasury money, money that you earn from selling, caseloads of toothpaste, to use that general treasury money to get your political candidates of choice elected, as long as it's an independent expenditure, that it's the corporations or the unions acting on their own behalf and not coordinating that expenditure with the campaign itself. Then it looks more like a contribution, and we think that there is enough risk of corruption to put limits on the ability of corporations and unions to give money to particular campaigns, but they can independently buy these ads that attack their opponent or promote the candidate. Well, the counter argument by the government was, well, you say it's independent, but it's really not. These candidates, they know who's making these independent buys on their own behalf. They feel gratitude towards the corporations and unions that are doing this. They're giving them special access. They're giving them sort of special consideration to their priorities. And that's where the Supreme Court said, well, as long as it's not quid pro quo corruption, we're not going to worry about it. The four more liberal justices dissented, saying, no, that's not our view of democracy. And frankly, I think that Citizens United was a big mistake in terms of allowing sort of, and it's not just an issue of corporation and union spending. In fact, I think the empirical numbers after Citizens United show that corporations are fairly careful about where they're placed their. I don't think there's been a huge increase in sort of funding that corporations have funneled into these ad buys on behalf of candidates. I think the greater problem today, frankly, is billionaires. That are able to spend so much money in these sorts of elections to get their particular candidates of choice elected, that I think it is really sort of distorting the marketplace of ideas out there and dominating it. And I do think that we need to sort of take a comprehensive look at all of this, but I don't think an amendment that says Congress shall make no law abridging the freedom of speech should prevent Congress or state legislatures from putting reasonable limits on the amount that people with inordinate wealth or corporations with inordinate wealth can spend on behalf of getting certain candidates elected.
Well, I think coming back to John Paul Stevens, who I think I quoted earlier, who said money is not speech. He retired from the Supreme Court, and then he was testifying before the Senate. This is about 9 or 10 years ago, and actually proposed. He said that while money is used to finance speech, money is not speech. Those financial activities should not receive the same constitutional protection as speech itself. After all, campaign funds were used to finance the Watergate burglaries, actions that clearly were not protected by the First Amendment. Now, that's his testimony before the Senate Rules Committee. And then he actually proposed a constitutional amendment. The way he would like it formulated read this way: neither the First Amendment nor any provision of this Constitution shall be construed to prohibit the Congress or any state from imposing reasonable limits on the amount of money that candidates for public office or their supporters may spend in election campaigns. What do you think about an amendment like that?
I love it. I don't think 5 or 6 lawyers appointed to the Supreme Court ought to be telling the American people how their system of elections can or can't be run. I think that if the American people want to take the lead of certain other sort of advanced democracies that have gone to systems of public financing of elections, just get private money out of governance. It's too much of, we all know that it leads to sordid deals. Maybe they're not quid pro quo bribery, as the court likes to say, but we all know that money drives a lot of public policy and lawmaking in this country. I mean, look at the lobby industry in Washington, D.C. and what goes on there. I mean, whenever the cover is lifted a little bit, it gets very messy. I think we as Americans should be able to say, even with the free speech clause in the Constitution, that we do not want people injecting their private money into who gets elected or what laws that they pass. That we should allow for a system of public financing that gives candidates a certain pool of money to run their elections. And then they really have to run on not how many ad buys or negative attack ads they can buy, but they have to run on the strength of their ideas and let the Americans choose. And for the Supreme Court to stand in the way of that, which I think would promote a much healthier democracy. We all know that most legislators don't legislate in the public interest. They legislate in favor of the people that are writing the biggest campaign check to their reelection campaign. That's the only way we're going to get legislators back that are going to actually legislate in the public interest.
Well, my sense, and maybe this is in the wake of Citizens United, is that the folks up in Congress, particularly on the House side, maybe because it's every 2 years they're elected, it strikes me that they don't really represent their individual constituencies, meaning the districts from which they run, as much as they represent the sources of the money, which is usually from the leadership. And what we end up having is leadership calling the shots without individual members. As a statesman, you would think they are, would stand up and say, that I know that's what my leadership agrees or wants to do, but I don't agree with it because my constituents wouldn't agree with it. But I don't hear that anymore. And am I off base on this, or am I misinterpreting that?
It's all part of the sort of the tribal warrior culture that has developed. I mean, everyone's an enemy who's not with us, and it's just all part of that. And I think it's really problematic.
Well, you bring a good point, and we'll talk about the unions also in just a minute. But you had these billionaires spending all of this money on these independent expenditures, but yet this billionaire only has one vote. You may be worth $100 billion, but you still only have one vote. And that person working at Starbucks, who's making maybe a little bit more than a minimum wage or a living wage, whatever the case may be, has one vote too. But yet that person who the barista can't contribute $1 billion or $500 million, however much it's going to be, to an independent expenditure. And that seems to me an inversion of what the founders would think of how a democracy should work. And thoughts on that?
Yeah, I mean, I don't think the founders were kind of complicated on the issue of electoral rights. They believed that mainly the landed gentry should have voting rights, on the theory that they were the people that were, got the education in those days, had the vested interest in seeing that, you had a sound and orderly society and so forth. So, the concept of one person, one vote is really a modern concept, and ironically, it was created by the Supreme Court in the early 1960s as a matter of the Equal Protection Clause, and which has created a lot of people say that's great because it's sort of ushered in sort of modern notions of electoral equality, but it's also created its own problems in terms of legislatures gerrymandering. So every 10 years you have the census, you have to conform to this one person, one vote for each voting district. So you have to redraw the voting districts. And of course, that's where you get these parties going at it and gerrymandering and disenfranchising a lot of the voters of the opposite party by the way that they draw the voting districts if they're in power. And so we have two real threats to our democracy going on right now, and that is, number one, partisan gerrymandering that is disenfranchising voters in many states, and number two, the private money that sort of drives a lot of our lawmaking in this country. So, and both of those can be traced back to our eminent Supreme Court, and at least the origins of these problems. And so we look to the Supreme Court. A lot of the average American puts the Supreme Court on a pedestal. They don't understand how the Supreme Court and some of their actions have really, I think, done a lot of harm to American democracy. And I'm actually working on a book to explain my point of view on that.
When might we see that book?
Oh, well, between all the other things I have to do, it may be a while, but I don't know.
Do you have a title for it yet, so we can keep an eye out for it?
Well, I'm thinking, this is sort of a divided we stand, how the Supreme Court has sort of exacerbated that whole problem. I need a catchier thing than that, but...
Well, wonderful. Well, we talked about corporations contributing to independent expenditures, but Citizens United authorized, treated essentially unions the same way as corporations, because unions are a legal organization in the same sense. But unions, I do believe, contribute a whole lot of money to independent expenditures as well. I think in California, I think they typically contribute $150, $160 million a year to every election cycle. I'm assuming that your reasoning for
absolutely applies to unions as corporations. I'm just using corporations since they tend to have such a bigger presence in our...
Well, and it kind of the Janus, another opinion of the Supreme Court, Janus, which is getting some age on it now too. I think it's 5, 6, 7 years old, maybe. Was the case that said that you cannot compel a member of a union. I think that was a public employee union case. Cannot compel a member of the organization which the union controls. You cannot compel that individual to pay dues that go to supporting political causes that the individual does not necessarily agree with.
Oh no, that was prior law. This decision went further and said that the union members couldn't be forced to just support the collective bargaining activities that got them additional benefits in their job, because it violated their freedom of association, which isn't in the Constitution, at least in this incarnation, to have to sort of pay money to a union that does things that they disagree with. And so to say that union workers, to say that people that don't want to join the union can't be forced to at least contribute to the collective bargaining activities, aside from political activities, that get them additional benefits in their job, I think just shows you how far the Supreme Court has come in terms of being a policymaker. They take that one word, free speech, they derive from that, okay, well, if there's free speech, there must be this sort of freedom of association in expressive matters. And since unions take positions on political issues that people don't want to contribute to, even if they're not being made to contribute to them, just the fact that they have to give money is sort of an infringement of that freedom of expressive association, and therefore it violates the Constitution. It just gives you, this is sort of a poster child of how the Supreme Court has taken these short and general phrases in the Constitution and supplanted the job of our lawmakers. I just think that we need to go back to an era of judicial modesty, judicial restraint.
Here we have a situation where in the wake of Citizens United, and it was always there before, but it's now on steroids. You have these election cycles. It's an industry. And people are running for office a year and a half, or 2 years before the election is held, and millions and millions and millions are being spent. And it supports a lot of jobs, which creates a lot of financial interest into supporting money into the system, which probably makes it very difficult to cause a change, restricting that money, because that means people are going to suffer financially. How do we deal with that?
I don't know. What particular problems are you thinking
Well,
about?
you always follow money, right? So there's a vested interest in maintaining an established money stream because it supports your jobs, and so if there's going to be some kind of political reform that turns off that money spigot, people will be against it, is what I'm trying to say. And so you're going to have serious to do the reform that you're mentioning. There would be a lot of political headwinds to get that through Congress or any state legislature as well.
Oh, you're talking about a system of public financing?
Yes.
Yeah, no doubt. I mean, I'm talking about enlightened legislators convincing their constituencies that this is in the best interest of the country.
Where are all
as
those
a
people
whole
these days?
I mean, at some point, hopefully, I do think, I'm not a naysayer. I do think societies progress and evolve. I think we're going to get to a point where people are just tired of, people trying to lead with this facade of doing it in the public interest, but really being out totally for themselves and whatever interests they're supporting. And I do think at some point we're going to get there. It's going to be a long time, but it's going to take social, political, economic evolution.
Well, maybe we'll get to that point sometime before my 1-year-old grandson.
Well, I don't know. I think I'm talking hundreds and hundreds of years.
A long time. Well, in this concept of being compelled to support speech that you don't necessarily agree with, I want to come back to the concept of legal organizations, whether they're unions or corporations. corporations have stockholders, you have employees, so that money that's in that general treasury account comes from the activities of the corporation, and the owners are the stockholders. And those stockholders may not agree with what the corporate executives, how they want to spend their money. I'm not sure, I'm kind of redefine that. So you've got, let's say you've got a corporation that has, let's say 10,000 shareholders of various types, and they're not all individuals, obviously. There's a lot of, subgroups on that now, investor groups and so forth. But they may have a liberal point of view. Or maybe they have a conservative point of view, but yet the leadership, the C-suites of the corporation are investing the corporation money, meaning the owner's money, into political point of views that they don't agree with. So it seems to me what the Supreme Court has said is that the C-suite, who makes the executive decisions for the company, it's their free speech rights at play, trumping the free speech of the owners who remain silent on the sidelines, is the way I see it.
I definitely think that that's was going on in the back of their minds, is that the executives have the right to steer the corporation into whatever causes that they support. And I do think there were actually some explicit arguments about this made in the case. And I think the response of the majority was essentially, you can sell your share. You don't have to remain invested in the corporation, or if you're maybe you can raise a stockholder revolt and, vote for board members that are going to change the executive team. So they did point out a lot of mechanisms that could hopefully mitigate the concern about compelled political support. But they also sort of, I think, discounted that corporations before Citizens United had a lot of room to donate politically and spend politically through political action committees, where the individuals in the corporation who wanted to contribute could do that. And they sort of said, oh, well, that takes too much administrative, regulatory stuff to administer, and we think that's too much of a burden on them. So I just think that, I don't know what was driving the justices in that case, but I don't agree with how they came out on it.
You mentioned public finance as an alternative. Are there examples in other countries that would be useful for us to look at, where public finance is how you finance a political campaign?
Well, I know Britain has an aspect of it, for a lot of their parliamentary elections. Although I'm not an expert in British finance at all, I do think that they do rely on party donations as well. But I know that they're, and I'm not an election expert. I mean, I could point you to some scholars in that area, and I don't want to tread on their ground. I know Vermont tried to go to a system of public financing that was, it was stopped on First Amendment grounds. So I do think that there are Western democracies out there that do use a system of public financing. I'm just not able to sort of identify those offhand. But regardless of whether there are or aren't, I do think it's a good idea. I mean, you shouldn't stand in the way of sort of adopting a good idea. Look at all the problems that private money in our political system creates. I mean, it's just obvious, and the only reason that it doesn't get changed is because certain interest groups are preventing that sort of change. And
well, it does seem that we're in a quandary with no clear way out, it seems.
Yeah, and this notion that, well, we don't want taxpayer money given to politicians to run campaigns. I mean, the benefits, first of all, you're talking 0.000, I mean, to the 100th degree in terms of the federal budget and state budgets, in terms of giving legislators pots of money. But the benefits in terms of governance, equitable, fair, good governance that would result from that, the payoffs would be way beyond the
Professor McDonald, I want to thank you for your time. It's been a wonderful discussion, wonderful interview. I look forward to having you back. You've been listening to the Fourscore and 7 Project. I'm Roger Clark. a production of the New Majority Foundation.